Recently, we have heard the case of Humans of Bombay versus People of India. They both are the online portals which publishes stories of human lives and their struggle. So what was the case? So in that case, Humans of Bombay had alleged that People of India has, copyrighted its content, and the matter went to the court. And what was the opinion of Delhi High Court onto this issue? So Delhi High Court had observed that People of India had copyrighted various contents from the Humans of Bombay, and it had been advised to the People of India to take down all the contents which are imitative in nature and which are similar in nature, because they had used similar kind of the image and imitative kind of the contents, and the stories were also in similar in nature. So this creates a case of copyright issues, and in today's class we are going to discuss that what was the copyright issues we have in India. Hello everyone, welcome to the new series of Drishti IAS. I am Ritu, and today we are going to discuss that how copyright issues can be applied to the religious text. So this topic is important from GS2 perspective. So moving to the points of discussion part. So first of all, we are going to discuss the news, and then we are going to discuss that how copyright issues can be dealt with the religious text, and then what was the copyright issues and copyright laws we have in this country, and then what is the petition about, and then what is the opinion of High Court into this issue, and then practice question for prelims and mains. So moving to the news part. So there is a trust whose name is Bhakti Vedant Book Trust. So it went to the High Court, and in the High Court it had alleged to the various online portals that they are using their original content without their permission. And in this case, the court had allowed this trust to approach various tech companies just like the Meta, YouTube, Instagram, to take down all the orders which has published this kind of the content which is related to the Srimad Bhagavad Gita. So this is the news we are going to discuss in today's lecture. So moving to the next slide. So next slide is about that are religious texts protected by the copyright? So we have various kind of religious texts in this country, especially Ramayana, Mahabharata, Srimad Bhagavad Gita. So are they protected under copyright things? So in general, they are not protected under the copyright things. So just like we can take the case of the Old Testament and New Testament, and also the version of King James Version. So they are not protected by any kind of the copyright law. But we can see that there are different kind of modern translations are going on, which are creating different kind of pictures regarding this kind of the Bibles, and they are messaging, and they are giving different kind of the message interpretation, and their version is really different. So all these modern translation and modern creation are protected under the copyright protection. So similarly, we have this case of the Ramayana and Mahabharata. So Ramayana has been, this serial has been very popular, and in the COVID times, it again became very popular. So this has a copyright issue of the Ramanand Sagar, and similarly Mahabharata has also the copyright issue of the B.R. Chopra. So these all are the creation of the two human beings who have projected all these epics in a different manner, where Lord Rama has been projected in a different manner, where Mahabharata has been projected in a different manner. Their stories are very different, their projections, their directions, their actings, their costumes. So all these things have been projected in a very different manner. So it's their creativity. So in this kind of creativity, they have this copyright thing. So this is the case. So moving to the next slide. Next slide is about that what does the copyright law in India we have. So we have this Copyright Act 1957, and it is a legal right which protects various original works related to literature, art, music, films, computer programs, and various other also. And what it protects? So it protects the expression of ideas rather than ideas themselves. So suppose that we have this idea of Mahabharata, and we know the story of Mahabharata. So we know that what is the generic thing about the Mahabharata, but in which manner we are interpreting the Mahabharata, or in which manner we are creating this kind of serial and we are launching into any digital platform. So that will have this copyright protection issue. So in this way, it safeguards the expression of ideas rather than the idea itself. So suppose that we have this idea, but we are not creating anything new to this idea. We are not adding anything new to that idea. So in that sense, the new things are preserved under the copyright protection law, but the idea does not protect under the copyright protection law. And it was first passed in 1958, and since that time there were severe amendments regarding this. And in 2021 also we have seen that this appellate board has been added to the Copyright Board. So in this kind of the amendment, we can see that Copyright Act can be seen various times. So moving to the next slide. Next slide is about that, what is the new thing about this Copyright Act. So we had already discussed that, it creates and it protects new kind of the creativity, new kind of interpretation, new kind of translation, music, art. So in this way, it is protecting the new kinds of the ideas, new expression of the ideas, and new believers of the ideas, new innovation. So this paragraph is about that. So it has also exemplified that, suppose that in 2015 we have this case of AIB. So they had created a song whose name is Every Bollywood Party Song. And earlier this kind of the song has been created by Honey Singh, which title is Party All Night. So they cannot have this copyright issues because they are inspired by the Honey Singhs, but they are not copied from the Honey Singh. So there is a difference between inspiration and copyright. So here this case has become the exclusive. So moving to the next slide. Next slide is about that, what was the petition about. So we are discussing about the trust. So what was the trust petition about this issue? So this trust is saying that, there is a author and there is a founder of the trust whose name is Srila Prabhupada. So Srila Prabhupada has translated and created different version of Srimad Bhagavad Gita and various scriptures, and they had also translated commentaries and different kind of works. So they are the original works of the authors, which has been used by various online portals without any kind of the license, permission and authentication. So this was the petition about. So we are discussing that what is the opinion of High Court, which is Delhi High Court, into this issue. So in the interim order, Delhi High Court has said that, all those works are original in nature and they have been originally translated by Prabhupada ji. So in that case, if any online portals or if any online medium is using their content, then they need license, they need permission, they need authentication. And they had been advised to take down all kinds of the video which are related to the Prabhupada's original works. So this was the observation of Delhi High Court into this issue. So this is all video about. Moving to the practice question for prelims. So the question is related to, on which day World Book and Copyright Day is observed. So here we are asking the World Book and Copyright Day. So you have to be very careful for the National Book Day and the World Book Day. So here your options are 23rd April, 10th October, 5th November, 18th December. So you have to answer this in the comment section. Moving to the mains question part. So the mains question is related to the IPR. What are different forms of intellectual property rights that exist in India, and discuss measures that can be taken to further enhance the strength of intellectual property rights. So you have to write it into 250 words. So first of all, you have to define that what is IPR, which is intellectual property rights. So in introduction, you have to define this term intellectual property rights, and it can be creation in various music, literature, art, films. So it can vary to different kind of, in fact, this digital thing is also have this copyright thing. And then coming to the second part of the question, that what are the different measures we have for this IPR. So we have different kind of intellectual property rights, just like the trademark, GI, patent, enforcement, international agreement. So these are the different kind of IPR we have this in the country. And then coming to the third part of the question, that what measures we can take to improve this IPR policy. So first of all, we have to look for the IPR policy 2016. So you have to carefully read this IPR policy 2016 and what amendment it requires you have to suggest here. And then you have to write that, this policy is very good and nature, but it is not implemented very carefully into this nature. And then we need different kind of innovation. We need to promote startup culture. We need to fund various innovations, and we need to increase stakeholders for every different kind of patent work, different kind of innovative work. And our copyright issues should be strictly managed. So in this way you can suggest the measures. So I hope you like this lecture. If you have any queries related to this lecture, kindly ask in the comment section. Thank you.